Advocate Skippers, we can proceed with the evidence.
Thank you, Chair. I think Advocate Raja Budlanger would like to address the panel before we start.
Oh, okay.
Thank you, Chair. And
there are always teething problems when a matter starts, so
absolutely.
we will all have to be patient.
Yes, absolutely. May I proceed, Chair? Thank you. My thanks to the Tribunal for permitting us to address you very briefly at the outset of these proceedings. I wanted to simply place on record our role in these proceedings. That has become even more clear just in relation to the submissions that Mr. Sikakane has just made when he raised the question of who represents the complainant in these proceedings. The simple answer, for the avoidance of any doubt, is that I represent the complainant, instructed by the Women's Legal Centre. But this is not a trial. And the Act here requires that the evidence leader's role is to collect the evidence and to present the evidence to the tribunal. That doesn't mean, in my view, that the evidence leader may not form view on the evidence that she collects, and there's a nuance here that one can debate and argue in due course to the extent that that's necessary, but I don't propose to do that, and I don't think that this is the moment to do that. What I simply want to say is the following. We have heard from the evidence leader, and on behalf of the complainant, we agree that under the Judicial Service Commission Act, the objects of the tribunal are to conduct an inquisitorial process and to inquire into whether the allegations against the judge president give rise to a finding on a balance of probabilities that he is guilty of gross misconduct. What that would require is for this tribunal to make findings of fact and to report on those findings to the Judicial Services Commission. So it is within the discretion of this tribunal to decide how these proceedings are to be run. We've heard already that, and we're aware that these proceedings are the first of their kind in South Africa, but it's not only the first of a kind, it is these proceedings concern sexual harassment, and we know that sexual harassment is a particularly nuanced, difficult issue to adjudicate because of the nature of the allegations and the impact that testimony has on both parties concerned. Sexual harassment is a form of violence against women in the workplace. So what happens during these proceedings in this hearing will send a message to South Africans about how the judiciary deals with sexual harassment and whether victims of sexual harassment in our courts feel confident about raising their complaints through this process. We accept fully that these proceedings today are to test the facts in this complaint and as they relate to the complainant and Judge President Mengo. But in our submission, it is important to record and recognize at the outset that this complaint does not arise in a vacuum, and that context is relevant to how the evidence that this tribunal will hear in the coming days must be evaluated. This complaint happens in the context that sexual violence against women is pervasive in the legal profession, and more broadly.
I don't understand what you're talking about, Advocate Butland. We're here to hear a particular complaint, a particular issue. We have been enjoined by the JSC to come and address a particular issue. I'm not sure what you're talking about.
Chairperson, what I'm asking this tribunal to take notice of is the fact that the way in which the evidence must be evaluated, the evidence that is presented to you, happens in a context. One must be aware of that context, and one cannot pretend that this is simply...
But we will do so when the time comes.
Yes, I have no doubt.
There's no evidence before us. How can we evaluate evidence? I'm desperately trying for us to get started and hear the evidence. I'm not so sure what your problem is, quite frankly.
No, Chairperson, I don't have a problem, but I am here representing the complainant. The complainant in a process such as this does not have her own voice in the process. To that extent, what I was getting to was that the Act requires that the evidence leader will collect the evidence and present that evidence to this tribunal. I will not be leading witnesses. I will not be cross-examining witnesses. This is the opportunity that I have to address this tribunal, and I thank you for that. On behalf of the complainant, we simply wish to say that this process, we ask that this process takes place in a way that is cognizant of the context in which it comes to you, and that it respects and protects her rights to be treated in a respectful manner during these proceedings. And let me be clear, I am not suggesting at all that this tribunal will not do so. but I simply wish to place that on record. Our role then, and the Women's Legal Centre's role, they deal with complaints of this type on a daily basis. And so as we see our role, it's to provide support to the complainant and to be available to the tribunal to the extent necessary. And so in due course, what we will ask this tribunal to permit us to do is to make oral and or written submissions at the end of the evidence to contextualize the complaint and the evidence. Those are the only issues I wanted to raise, Chairperson. It's nothing more than that. I thank you for the time.
I may have to assure you about something, but let me first consult with members of the panel. Advocate Butland, it may well be that after the lead of evidence has led the evidence, it may well be that I'm trying to address a concern that seems to be there at the back of your mind. It may well be that you may be given the platform to put questions to your client if you feel there are certain important aspects which the lead of evidence didn't cover, which you would like to cover with your client. Does that address some of your concerns?
Chairperson, it's not really a concern of mine. I have full faith in the evidence leader. Our bigger concern is that this is the process that all complainants will face in similar matters, and not all of them will have access to pro bono legal services or the Women's Legal Centre. So it is important to us that this process runs as the Act anticipates that it will run. And we thank you for that opportunity. I'll take instructions, and if you would permit me to raise that issue down the line, should we need to ask questions. It wasn't necessarily an enormous question at the back of my mind, because we do, as I say, have full faith in the evidence leader and running this process. Thank you.
Well, I'm putting that to you because in the context that earlier we asked the parties, the legal representatives, whether they prefer to lead their own clients. And the respondent's choice was that he would like to be led, would like his evidence to be led by his legal representative. So one would imagine that you could easily have said so yourself, but you prefer to rather use the lead of evidence. That being so, raises the possibility for you, once the lead of evidence has finished, if you feel that from consultation you have had with your client, there are certain areas which have not been properly covered, then you can do so, provided it will be, of course, before the cross-examination.
Thank you very much, Chair. We appreciate that.
Is there something else again before we start?
Chairperson, if I may just for certainty, according to the rules regulating the proceedings here today, Rule 7, Sub-Rule 2, says the evidence leader may then examine the witnesses which he or she intends to call to prove that the respondent is suffering from an incapacity, is grossly incompetent, or is guilty of gross misconduct, and may adduce such evidence as may be admissible. And to relate with that, 7 Sub-Rule 5, the respondent may examine the witnesses which he or she intends to call to refute the allegations against him or her, and may adduce such other evidence as may be admissible. So I hear what Advocate Sikakani is saying now, that they want me to call their witnesses. But according to the rules regulating these proceedings, the evidence leader's role is to lead all the evidence to prove the complaint, and the respondent's legal representatives must lead the witnesses to refute the claim. The problem is I haven't consulted with their witnesses because they are actually not my witnesses, and I will not call them to prove the case. So I just need clarity on that.
Let us not run ahead ourselves. Those witnesses may be there, they may not come. Let's not spend time talking about witnesses which are not before us. We will deal with that part when it comes. Let us deal with what is here in front of us now, please. In any event, the rule or is the act says the tribunal has the power to determine its own procedure. So we have got the power to determine our own procedure as to who should stand up and who should sit down, who should speak, who should shut up. We have got that power. We'll deal with those things, please.